Joining us for a few minutes, we have Mitch Kokai. We want to talk about a Supreme Court case involving a local medical practice, and that's Dr. Singleton, eye doctor, who's looking for the ability to conduct his practice unfettered by state regulations. We'll get to that in a moment, but first, want to welcome to the program Mitch Kokai. Mitch, good afternoon. Thanks for joining us.
Good afternoon, Lockwood. Thanks for having me.
Dr. Singleton has made a presentation, I say he, his attorneys, to the state Supreme Court over CON, that is Certificates of Need. Tell us something about the case at this point.
Yes, so this case has now reached the highest court in the state, so this will be the place where these issues are ultimately resolved. For those who haven't been following the case, Dr. Jay Singleton is an eye surgeon based in New Bern. He has the Singleton Vision Center there, and what has prompted this lawsuit is that the state does not allow him to perform most eye surgeries in his facility, even though it's a facility that is perfectly fine for eye surgeries. His patients would like to have the surgeries there. They would be much less expensive than they otherwise would be if the surgeries are there. But because of the state Certificate of Need law, or the CON law, most of these surgeries have to take place a couple of miles down the road at Carolina East, because Carolina East is the only facility within the region, and it's a three-county region, that has a CON or an operating room at which a surgery could take place. Now, the way that the rules are set out, because Dr. Singleton has no CON, he can't perform these surgeries, and the state has not determined that there is any need for any other place to have these surgeries. He could, if he wanted to, ask the state to amend its plan to say that there is a need for more surgical capacity in that area. But if that happened, the state would then open up the process to get a CON, and Dr. Singleton would have to compete with Carolina East and perhaps anyone else who wants to get in on the game to try to get that CON, rather than just saying, you have this business, you have a facility that works, you are certified to do this process, go ahead and do it. So he launched a lawsuit several years ago saying, this whole process is unconstitutional, it's blocking me from being able to earn the living for which I am trained, it's an unconstitutional process that steps on my rights. He has lost at the lower court levels, at both the trial court level and at the state court of appeals. But the state Supreme Court agreed to take up his case basically a couple of years after he appealed it from the state court of appeals. And this week we had the oral arguments in his case, and there are quite a number of interesting questions from the justices about whether this type of process is justified or not.
North Carolina has one of the most constraining CON laws in the country. And as a matter of fact, there are only maybe 20 states that still have Certificate of Need laws.
I think there are more states than that still have Certificate of Need, but you were exactly right that North Carolina's law is one of the most stringent. There are a number of states that have no Certificate of Need law, and there is no evidence anywhere on the record that health care is worse or health care is more expensive or is in any way lesser in those states because they don't have the law. To take another step back, most states adopted Certificate of Need after the feds forced them to do it. The federal government basically said that it was going to try to fight rising health care costs, and the way that it was going to do it was to stop all of these health care providers from buying large pieces of medical equipment or adding hospital beds or adding facilities that they didn't really need and that would eventually have to close, and then that would lead, because of the closures, to higher prices elsewhere. And it basically flew in the face of anything that anyone knows about the economy and how competition works, that if you have more access to these various facilities and procedures and equipment for people competing for consumers, the price will go down, the quality will go up. And so once the federal government decided in the late 1980s to get rid of its CON requirement, stopping states from having to have the laws, a number of states got rid of their CON laws. North Carolina didn't. North Carolina has adjusted its law over the years, but it still is one of the more stringent in the country.
Apparently, this has gotten the attention of the Supreme Court, but I got the impression that questions by the court didn't give any indication one way or the other as to how this decision might be adjudicated.
No, you're right about that, but a large part of that is because some of the justices who asked questions were really sort of trying to play with hypotheticals and to get the lawyers on both sides to concede to various issues. So, for example, Justice Richard Dietz had some very in-depth, detailed questions for lawyers on both sides, but it sounded as if he was trying to get them to parry with him about some of the legal intricacies rather than hinting about how he felt about this case. There have been some other cases that the Supreme Court's heard over the past couple of weeks in which it was pretty clear which way they're going to come down. On this one, it was not quite as clear. You got a sense that they did have some concern about the state telling this doctor that, no, you can't provide this service just because the government has dictated from on high that only this one hospital within a 3-county region is going to be able to have the government's permission to do this work. But that didn't necessarily translate into them saying, we're going to kill off this law. Now, another reason why they're not going to necessarily kill off the Certificate of Need law is that is not the way that Dr. Singleton has approached the case. There are a couple of different ways that you can challenge a law's constitutionality in North Carolina. One is called a facial challenge, where you basically say this law can never be constitutional under any circumstances. The law needs to be thrown out. The other type of challenge is called an as-applied challenge, and that's what Dr. Singleton's doing. He's saying whether the con law could exist at all, in my circumstance, it's being applied unconstitutionally. And so the Supreme Court could strike down the con law as it applies to Dr. Singleton without having to strike down the law in its entirety. And that's one of the reasons why some of the questions went the way they did, because justices were asking, well, if we strike it down here, is it going to stand in any other place? And Dr. Singleton's lawyers didn't want to say, well, no, basically no one would ever have to go through the con process again. They said, well, all we want is for our client to win. Whether there are downstream effects or not, I can't say for certain. And also the question was asked, well, if the state decided to give him a certificate of need today, would his case be moot? The lawyers for the state said yes, because there'd be no reason for it. Dr. Singleton's lawyer said, well, maybe, but the process that he is challenging is not actually getting the con. It's having to go through the state-mandated process to get the con. If they just gave him a certificate of need, that wouldn't address the issue.
Could the legislature eliminate or in some way alter the certificates of need? I thought there was an effort to do just exactly that several years ago through legislative action.
Yes, the General Assembly could get rid of certificate of need in its next session if it wanted to. There have been efforts to completely eliminate certificate of need. Those have gone nowhere, and there have been some efforts to scale back parts of certificate of need, and that has been successful to some extent. It's interesting that you asked that question because that really is one of the key arguments from the state about this case. But basically, the lawyer who represented the State Department of Health and Human Services, Governor Roy Cooper, and legislative leaders who are all defendants in this case, he said, look, this is a political process. This is something that the General Assembly can take care of on its own, and what the plaintiff in this case, Dr. Singleton, is trying to do is to take this out of the political process and have the courts step in and get rid of certificate of need. Now, in other cases, we have seen some concern about folks on the other side of the aisle trying to win through the courts what they can't win at the ballot box. This is what the state is accusing Dr. Singleton of doing, and you're absolutely right. The General Assembly could strike down certificate of need at any time, and we at the John Locke Foundation have been urging them to get rid of certificate of need completely for years.
Well, it basically, I think, artificially raises the cost of health care. And by the way, certificate of needs also apply to situations such as long-term care facilities. So it's not just a medical facility, it's even facilities that provide care for the elderly, the indigent, things of this nature. So yes, I know that North Carolina Senator Norm Sanderson has been on the hustings to remove certificate of needs as well. So I appreciate that from Senator Sanderson.